Hello friends, in this video lecture we will be discussing MCQs based on contract law. Contract law. Okay, so we will be discussing MCQs based on contract law. So MCQ number 13, an erroneous opinion as to the value of the thing which forms the subject matter of the agreement is. So the right answer over here will be option B, not to be deemed a mistake as to matter of fact. So it will not be a mistake of fact, neither it will be a mistake of law. Why? Because there is an erroneous opinion on which the party relied. So there is no mistake of fact. The opinion on which the party relied was wrong. Okay. MCQ number 14. It is necessary requirement that in order to bind the parties to the contract, the terms of agreement must be, so it must be definite and it must be capable of being made definite. So the right answer over here will be option C. MCQ number 15. Which of the following is void under section 30 of Indian Contract Act? Okay. So the right answer over here will be none of the above. तो सबसे पहले सेक्शन 30 कहता क्या है? सेक्शन अकॉर्डिंग टू सेक्शन 30, any contract which has an element of wager, of which is a contract of wager, of betting, such contract will be void. Okay, and the person who has won the bet will not cannot enforce it in the court of law. Okay, but under section 30 only there is an exception made to horse race. Okay, therefore horse race will not be void. Also, if we see that crossword competition, there is some element of mind involved in it, so there is some competency involved to win in such crossword competition. Therefore even such crossword competition will not be under the term of wager or betting. Okay, then we have lottery. So lottery is not also under wager or betting. Why? Because wager is what, in which it depends on happening or not happening of a certain event, of an uncertain event. Okay, happening or not happening of an uncertain event. But in lottery there is no such happening or not happening of a particular event which is uncertain. Okay, lottery is that there is a game, you have a ticket. Okay, so it's based on luck a lot, but it is not on happening of certain event or not. It is not dependent on that. So therefore even lottery will not be included in the word wager. Okay, so the right answer over here will be none of the above. MCQ number 16. a con- a contingent contract to do or not to do anything on the happening of an uncertain event under section 32. Okay, so such contract can become enforceable at the happening of that event. When that event happens, then it can be enforced, but not before that. Okay, so the right answer over here will be option B. An agreement with minor is, so the right answer is void, that it is void. A promisee can accept the performance. So the right answer over here will be all of the above, from the promisor himself, from the representative of the promisor, or from a third person also. MCQ number 19. In case of default by joint promisor, the promisee, so the right answer over here will be option A, that he can sue any one of them for the entire promise. Okay. MCQ number 20. A person enjoying the benefit of lawful non gratuitous act of another. So the right answer over here will be he will be liable to compensate that another person. So the right answer is option A. So अगर आपने किसी के एक्ट का बेनिफिट उठाया है, then you have to do the payment for it if you knew that this act is not for charity. Okay, this is related to quasi contract. Okay, this is related to quasi contract. MCQ number 21. A and B, being traders, entered upon a contract A has private information of a change which would affect B's willingness to proceed with the contract. So the right answer over here will be A is not bound to inform B. ठीक है, क्योंकि इसकी private information है and he is just using it to make his negotiation better. He is not bound to inform B. MCQ number 22nd, where the proposal and acceptance is through letters, the contract is made. So this one is an interesting one. The contract will be made at the place where acceptance is received. तो ये क्वेश्चन इंपॉर्टेंट हो जाता है टू डिसाइड दैट जुरिस्डिक्शन ऑफ द कोर्ट. तो कोर्ट का जो जुरिस्डिक्शन है उसको डिसाइड करने के लिए ये क्वेश्चन इंपॉर्टेंट हो जाता है. MCQ number 23rd, where there are two or more courts which would normally have the jurisdiction, and agreement to file suit in one of those court alone is. So the right answer will be valid. That it will be valid and it will not be against 28, because in 28 the provision is there that if two or more court are having their jurisdiction, then there can be agreement that in one of the court the suit will be filed. It is only that one cannot have any term which avoids the party to file the suit entirely. Okay. MCQ number 24, an acceptance containing addition, limitation or other modification shall amount to. तो देखिए acceptance shall be absolute and there should be no changes in that. If change is made, then it will be a counter offer, it won't be a acceptance. Okay. MCQ number 25th. For a loan amount when there is a stringency in money market, a banker asks for an unusually high rate of interest. A accepts the loan on these terms. This is, so see, this will be a valid transaction in the ordinary course of business. Why? Because there is stringency in money market. Therefore, banker has asked unusually high rate of interest and A has accepted it. So this is not the case of some undue influence or coercion or fraud. Okay, mere economic difficulty cannot be said to be the case of undue influence. ठीक है. MCQ number 26. If promisee accepts the repudiation of contract on anticipatory breach committed by the promiser, then अगर promisee को लगता है कि there can be an anticipatory breach by the promiser, okay, then the promisee, the right answer over here will be option C, that the promisee need not perform his part of the contract and can claim damages without waiting till the date of performance. Okay. MCQ number 27. An employer asks his employee or servant to sell his servant's good at a price for less than market price or fair price. Servant can avoid the contract on the ground of, so there is a clear case of undue influence, that employer is in a position to dominate the will of the servant or employee. MCQ number 28. A bare promise devoid of consideration is called. So a bare promise devoid of consideration will be void. Okay, it will be like no promise at all, so there will be nundum pactum. So the right answer over here will be option B. MCQ number 29. Offer has been defined under, so the right answer over here is option A, section 2A. MCQ number 30. Under section 2 subclause B, if the person to whom the proposal is made signifies his assent or gives his assent to the proposal, then the proposal is said to have been accepted. The right answer over here will be option A. So these were some of the MCQs regarding the contract law. In next video, I will be discussing more such MCQs. So thank you all.